very briefly, these three areas of immigration policy, immigration law, directly impact hundreds of thousands of Angelenos and millions of people nationwide. LA County has taken a very strong and clear stance in support of our immigrant communities around the issues of public charge, and administration's attempts to terminate DACA and TPS for years. We're the home to the largest number of DACA beneficiaries in the country, and one of the largest communities of TPS holders, and probably the largest community of people potentially impacted by the public charge rule. And so the Board of Supervisors opposed the change to the public charge rule. It opposed the termination of DACA, and then the county has supported litigation contesting the public charge rule and the termination of DACA. And then our office, the Office of Immigrant Affairs, has worked to support immigrant communities impacted by these policies, both connecting them to service providers, conducting outreach and education events so that folks understand their rights and what is actually happening with these significant policy changes. After some very difficult years, I'm pleased to say that there are some very positive developments that I want to share, and we are optimistic that we will have additional positive developments to report in the coming months. So I want to address some of those today. With regard to DACA, the DACA program for those who have held DACA or who've been seeking to apply for the program, this has really been a roller coaster ride the last 4 years. It has been very difficult, I think, emotionally, to say the least, for people directly impacted. Do want to make clear that first-time DACA applications are now being accepted by U.S. Citizenship and Immigration Services. So current and outgoing administration attempted to end the DACA program in 2017. There were legal challenges to their attempts to end the program that resulted in the Supreme Court reviewing the matter in June of this year. The Supreme Court determined that the administration's attempts to terminate the DACA program were essentially in violation of the law, leaving the original DACA program in place. This administration then tried to narrowly interpret that decision by only allowing people who already had DACA to continue renewing their work permits. As a result of subsequent litigation, as of December 7th, U.S. Citizenship and Immigration Services is now accepting new initial DACA applications for people who qualified under the original rules established in 2012, but who had not yet filed a first-time application. The bulk of these individuals are people who turned 15 on or after the period in the fall of 2017 when this administration attempted to wind down the program. I want to also note that as a result of litigation, people who received a 1-year DACA work permit have now had automatically their work permit and their authorized period in the US extended to a 2-year period without having to take any further action on their part. And then people seeking to travel outside the country and return lawfully in a process called advanced parole are now allowed to apply for those travel permission requests under the rules originally established in 2012. I do want to note that there is uncertainty that continues to surround the program. Texas and several other states have challenged the constitutionality of the original DACA program. And there's a hearing in that litigation tomorrow. And so there does remain an air of uncertainty around the program. Most legal advocates, meanwhile, are recommending that individuals eligible under the initial, who meet the initial requirements, file their applications now while the period is clearly open. And I will just note that the original DACA program has already survived several legal challenges. It is impossible to predict what will happen in the hearing tomorrow or in the litigation that I've referenced. But I will note that the incoming administration has committed to protecting the program and to seeking legislation to provide a path to citizenship for DACA beneficiaries and others who came to the United States as children. As far as local capacity, there are certainly challenges in recent days as a large number of individuals have come forward to apply for the program for the first time. and the fee assistance that the state of California had made available so that people wouldn't have to pay their filing fee with USCIS has been exhausted, but individuals seeking a legal service provider or who may be interested in a low or no interest loan program, there's at least one still very viable no interest DACA filing fee loan program, can contact the Office of Immigrant Affairs to be connected to those resources. And I'm going to post here in the chat some info that we've put on our website about the DACA program. And then I want to jump into public charge. So on the public charge rule, that our prior speaker Anna Gorman has referenced both today and last week, I do want to make clear the rule that this administration began implementing in February of 2020, just before the pandemic, is currently blocked in the courts. That means the rule is just not in effect. A person who has an interview for their green card today with U.S. Citizenship and Immigration Services is not subject to the new public charge rule. This is an extremely positive development. Now, we know that this outgoing administration has indicated in writing it is reviewing the decision blocking the rule. It may seek review of that decision by the court, another court of appeals, or the U.S. Supreme Court. But for now, the rule remains blocked, and it is at least possible that the rule will never be in effect until the incoming administration takes office. And again, the Biden administration, the Biden campaign committed in writing to reversing the public charge rule and taking action to do that in its first 100 days. And I do want to make clear that the administration has full legal authority to implement that rule change when it takes office. In the meantime, I want everyone to keep in mind that notwithstanding any legal challenges to the currently blocked new public charge rule, USCIS clarified at the outset of the pandemic that COVID testing, treatment, and preventative care is exempt from the public charge rule. Really important, especially as we move into a phase of implementing a vaccination plan nationwide. Really important for folks to understand they can get tested, get the treatment, and then get that vaccine when their turn comes up without having any public charge concerns. But we know this rule, even while blocked and even before it went into effect, has had an enormous chilling effect in immigrant communities nationwide. The #1 phone call that the Office of Immigrant Affairs has fielded during the pandemic involves access to county programs and services, and whether there may be immigration consequences. In other words, public charge concerns. So I want to just clarify a couple things. First, many immigrants are not subject to the public charge rule at all. This includes legal permanent residents, most legal permanent residents, and humanitarian relief immigrants, asylees, and other humanitarian-based immigration relief applicants and beneficiaries are not subject to the public charge rule at all. Many programs and benefits are not considered in the public charge test at all, like the county-funded My Health LA program, and many state-funded benefits and programs are simply not considered in the public charge test. And then most immigrants subject to the public charge rule just aren't eligible for the benefits considered in the new rule anyway. This is all very confusing, and that's why we encourage folks to reach out to us if they have questions, concerns, fears about accessing a county benefit or program. Again, the #1 question we've answered during the pandemic has been, can I access X, Y, or Z benefit or program in light of my public charge fears and concerns? And I'm going to also post in the chat a little bit of info about that from our website. And then finally, I do want to address the issue of temporary protected status. LA County is home to about 30,000 temporary protected status beneficiaries, the largest single country of origin being El Salvador, followed by Honduras, but also many other individuals from Haiti, Nepal, Nicaragua, Sudan. And the Department of Homeland Security announced, despite this administration's attempts to end temporary protected status and force individuals from those countries that I just mentioned to return to their countries of origin, it is extending temporary protected status for those countries through October 4th, 2021. This is as a result of litigation by the ACLU of Southern California, the National Day Laborers Organizing Network, and the National TPS Alliance, coordinated by a local organization, CARESN, the Central American Resource Center, that has essentially forestalled the administration's attempts to end TPS. That means folks from those countries are protected through October 4th, 2021, when we will have a new administration which has full legal authority to extend temporary protected status and has committed to doing so. I do want to just, before wrapping up here, note that individuals whose TPS is extended, individuals from El Salvador, Haiti, Honduras, Nepal, Nicaragua, and Sudan. This is for folks who already hold TPS. It is not a new designation that allows individuals from those countries to apply for the first time. And then I do want to point out that the status and the employment authorization is automatically extended. People from those countries currently hold expired work permits, but employers and then government agencies at all levels, federal, state, and local, are required to accept an expired work permit with the automatic extension date through October 4th, 2021 by virtue of publication in the Federal Register. People with TPS are not required to pay for nor present to their employer or a benefit providing agency a new work permit with a with what appears on its face to be a unexpired date. Those documents have been automatically extended. Important to report that out. And if individuals in the community are being denied employment or benefits on account of having an expired card, despite their status being extended automatically, we encourage them to contact the Office of Immigrant Affairs for more information and to get connected to a legal provider. And with that, I will wrap up. I think we've only got 3 minutes left.